My Lords, I would like to begin by speaking to some of the amendments made in the other place, starting with Amendments 1 to 31. These will ensure that smart data schemes can function optimally and that Part 1 is as clear as possible. Similarly, Amendments 35 to 42 from the other place reflect discussions on the National Underground Asset Register with the devolved governments. Finally, Amendments 70 to 79 make necessary consequential updates to the final provisions of the bill and some updates to Schedules 11 and 15. My Lords, I will now speak to the amendments tabled by Noble Lords, starting with those relating to sex data. Starting with Amendment 32A, which disagrees with the motion to remove subsections 3 and 4 in Clause 28, and instead proposes changes to the initial drafting of these subsections. These would require the Secretary of State, when preparing the trust framework, to assess whether the 15 specified public authorities are able to reliably ascertain the data they collect, record and share. Amendment 32B limits this assessment to sex data as defined through Amendment 32C. That definition limits sex to biological sex only and provides a definition of acquired gender. I think it also relevant to speak at the same time to Amendment 52A, which disagrees with the motion to remove Clause 140 from the bill and instead suggests changes to the drafting. Clause 140, as amended by Amendment 52B, seeks to, through a regulation-making power, give the Secretary of State the ability to define sex as being only biological sex in certain areas or across public sector data processing more widely. Let me start by making clear that this government accepts the recent Supreme Court judgment on the definition of sex for the purposes of equality legislation. We need to work through the effects of this ruling holistically and with care, sensitivity, and dare I say it, kindness, and in line with the law, taking care not to inappropriately extend its reach. This is not best done by giving the Secretary of State the power to define sex as biological in all cases through secondary legislation, without appropriate scrutiny, given the potential impact on people's human rights, privacy and dignity, and with the potential to create legal uncertainty. Likewise, giving the Secretary of State a role in reviewing how other public authorities process sex data in all circumstances, based on that definition, would be inappropriate and disproportionate, noting that the Supreme Court's ruling is specifically in relation to the meaning of sex in equalities legislation. The driver behind these amendments has been the importance of sex data being accurate when processed by public authorities. I strongly agree with that aim. Accurate data is essential. This government takes data accuracy, including the existing legislation which requires personal data to be accurate, and data standards seriously. That is why we are addressing the question of sex information in public sector data. First, the EHRC is updating its statutory code of practice to support service providers in light of the Supreme Court judgment. Second, the Data Standards Authority is developing data standards on the monitoring of diversity information, including sex and gender data, and the effect of the Supreme Court judgment will be considered as part of that work. Third, the Office for Statistics Regulation published updated guidance on collecting and reporting data and statistics about sex and gender identity data last year. And fourth, the Office for National Statistics published a work plan in December 2024 for developing harmonised standards on data more generally. Finally, the departments are currently considering the implementation of the Sullivan Review published this year, which I welcome. When it comes to digital verification services, I can reassure Noble Lords that these measures do not change the evidence that individuals rely on to prove things about themselves. The measures simply enable that to be done digitally. This government is clear that data must be accurate for the purpose for which it is being used and must not be misleading. It should be clear to digital verification services what the information public authorities are sharing with them means. For example, and this is an important one, if an organisation needs to know a person's biological sex, this government is clear that a check cannot be made against passport data, as it does not capture biological sex. DVS could only verify biological sex using data which records that attribute specifically, and not data which records sex or gender more widely. I know that this is a concern of the noble Lord Arbuthnot, and I hope this provides some reassurance. The data accuracy principle of GDPR is part of existing law. That includes where data is misleading, a point that I will return to. I hope noble lords find this commitment reassuring and as such agree with Commons Amendment 32.